podcast is provided for informational and educational purposes only and should not be construed as legal advice. Because every situation is unique, you should consult with a qualified legal professional for advice specific to your circumstances. If you need legal guidance, please reach out to an accredited attorney or contact us to schedule a consultation. Hello, and welcome to the Veteran Benefits Podcast. I'm your host, Rebecca Deming. Today, we are going to be diving into protected ratings. So, have you ever heard someone say, I've had my VA disability rating for 5 years, VA can't touch it now? Unfortunately, that's one of the biggest myths that we hear. There's a lot of confusion around what's protected, when something's protected, what permanent means, what temporary means. So, we're going to dive into a lot of that today and hopefully answer some of your questions. So there really isn't just one type of protection. I think that's one of the biggest misconceptions that people have, that it's either protected or it's not protected, black or white, yes or no. There's different levels of protections, different types of protections, and we're going to dive into what each one means and how it might apply to your situation. So we'll talk about static disabilities, routine future examinations, temporary ratings, temporary total ratings, the 5-year rule, the 10-year rule, and the 20-year rule, what permanent and total means, what happens if you're over 55, and common mistakes that can accidentally trigger VA to reopen something that otherwise would have been a permanent rating. So to understand why something might be protected or not protected, it's important to understand that VA is generally trying to compensate veterans for the average loss of earning potential, the average level of functional impairment in their life caused by the disability. And so if VA thinks that something is stable, that it's not going to change, that there's not a high likelihood that the condition could get better, they are less likely to reopen it and schedule a future exam. If there's enough reason for them to think that it's going to stay the same, you're likely going to be safe with the exam. And so what VA does is they will label specific conditions as either static or subject to routine future reexamination. And you don't see that on the rating decision narrative that you get in the mail from VA. I don't think that VA is showing whether a condition is static on the veteran-facing app or on their website. If you guys are seeing that, please put that in the comments. I'd be curious to see if you guys can see if a condition is static. But typically, we can see that it gets written down on the code sheet, which is a paper that we can see in your claim file. And if you call VA, you can request a copy of the code sheet. And under each condition, it will either say static or not say static. And static is VA terminology for a stable condition, meaning VA is not planning on requesting a routine future reexamination for that condition. It doesn't mean that they can't reopen it, but typically, once it's static, VA is not of their own accord going to go out and schedule a new examination for that condition. There's also temporary ratings. So you can have a temporary total rating, like immediately after a surgery. You might have a total rating for a period of time, depending on the type of surgery and VA's rating schedule, because VA understands that while you're in the hospital or recovering from surgery, you can't work for a period of time, but you're likely going to get better and stuff is going to improve for you. So they'll give you that 100%, and then they'll rate the residuals. What happens, after the sutures heal up? Do you still have a painful scar? Do you have medication side effects? Same thing with cancer. Typically, VA will give you a 100% rating while you have active cancer. But when the cancer goes into remission, defined by the doctor, if the cancer is no longer an active cancer, then VA rates the residuals of that. So it could be scars, it could be residuals from radiation, fatigue, issues with your lymph node or your immune system, depending on where the cancer was. Sometimes we have people who have issues swallowing or chewing food because it impacts saliva glands. So it sort of depends on what the residuals are. If it's a prostate cancer, if it goes into remission, or bladder cancer, if it goes into remission, do you still have urinary incontinence? So those are the types of things that VA looks for if a condition is presumed to be a temporary rating, they will later reevaluate for the full level of disability for that condition. There's other conditions that they're not temporary by nature, but VA might presume that there's a high likelihood that they're going to improve over time or that they might improve over time. So right when you get out of service, things like mental health condition are often subject to a routine reevaluation. There's a lot of stress. You're switching from a career in the service to civilian life. There's a lot of moving pieces of adjusting to that life. And VA kind of expects it to be a tumultuous time. And there's a good chance that for some people that the condition is going to improve over time. So mental health is one that we often see VA schedule future reexaminations. But things that are less likely to improve over time, so tinnitus, ringing in the ears, once that starts, we usually see lifetime symptoms or recurrent symptoms. It's not something that typically gets better. Obviously, if you have an amputation, we don't expect your limbs to grow back on their own. So a lot of things, once you have that condition, VA is more likely to mark that it's a static condition, and they're not going to schedule it for a re-examination. Right. So generally, VA will not schedule routine re-examinations if the condition is static, if the symptoms have remained stable for several years, if the disability is permanent in nature, if the minimum scheduler rating has already been assigned. So, for example, for painful motion of joints, VA typically assigns a minimum rating of 10%. So if you have that 10%, VA generally won't schedule you for a re-examination because the pain might have gotten a little bit better. There's not much that they can measure because it's not based on range of motion. It's based on having the minimum compensable rating. Same for tinnitus. Ringing in the ears is currently rated at 10%. Even if the ringing goes down a little bit, the minimum rating is the 10%. VA is not likely going to reschedule you for an exam because there's not much that they can do to reduce that. If the veteran is over 55, typically VA won't schedule routine reexaminations. Again, if it's something that's a temporary total rating, like after surgery or after cancer, VA might look at it again, but generally they won't schedule routine reevaluations for more routine conditions after you hit 55 years old. I guess VA assumes that it's only downhill from there. But yeah, they're not going to, if you're younger, I think they might expect some improvement over time and they might be more inclined to look into the rating. But after 55, the general rule is that VA won't schedule those reexaminations. And then if you are permanent and total, so if you have a permanent and total rating, meaning that your combined rating is 100%, VA is not going to re-examine each piece of that over time because it's likely not going to decrease your combined rating. So if you have 100%, and we have other episodes on the VA math, but if you're above 100% and VA is going to potentially reduce one of the ratings but doesn't impact the combined rating, it's just a waste of their resources and their time. So they're not going to schedule routine reevaluations if you're 100% total and permanent. So the over 55 rule, I think there's a little bit of confusion around that one too. People think I'm 55, VA can't re-examine me. That's not true. As I mentioned, there's specific things like if it's a temporary total, VA certainly can re-examine. And it's not a protection. It's just kind of a general policy rule that VA won't re-examine after 55. But if your medical records show sustained improvement of a condition, VA could reopen it. If you file for an increased rating or if you file for other conditions that trigger VA to look at that condition, VA can still reopen that rating and they can reduce it if the evidence supports a reduction in the rating, right? So we'll go into more detail about why it's important to understand how your actions can trigger VA to reevaluate something, and that could trigger a reduction. Okay, I want to talk a little bit about the 5-year rule, the 10-year rule, and the 20-year rule for protections for VA claims. So the 5-year rule is that after a condition has been rated for 5 years at a certain level, VA cannot reduce that rating without evidence of sustained improvement. So if you went in for just a single CMP exam and that showed a little bit of improvement, that's not enough for VA on its own to establish sustained improvement in the condition over time. So a lot of times VA, if they wanted to reduce a rating, they would have to have multiple CMP exams, or you would have to have medical evidence that you're no longer having symptoms, not just a lack of treatment records in your record, but evidence that the condition has gone into remission, is no longer bothering you. That, if you were having headaches and you told your doctor, I never get headaches anymore, this new medication is a miracle drug, something like that. If you have evidence of sustained improvement over time, VA can reduce it after 5 years, but without that, they can't. Before that 5-year period, if VA did schedule a new exam, or if you somehow triggered VA to schedule a new exam, and you have one CMP examiner that's showing symptoms at the 30% level, and you have the next one shows symptoms at the 10% level, VA can propose a reduction and reduce your rating. And we'll go through what happens when there's a proposed reduction as well, because that's a process, and there are some protections in there. You have some rights related to what VA has to do when they want to reduce a rating. So the 5-year rule, again, not a total protection. It just makes it a little bit more challenging for VA to reduce a rating. At 10 years, there's another protection. It does not protect your rating, but it protects service connection. So if you have had migraines rated for 10 years, VA could still go in and reduce them from 50 to 30%, or from 30 to 10%, or even down to 0. But they cannot go in and say, you no longer have migraines, you no longer have a service-connected migraine condition. So they can't sever service connection after 10 years without evidence that the original grant was clearly and unmistakably erroneous, or evidence of fraud. So there is that protection of service connection at 10 years. The rating could still be reduced theoretically after 10 years. Then you have the 20-year protection. And so if you have had a rating continuously for 20 years, VA cannot reduce that rating or sever that rating without evidence of fraud. So after 20 years, that rating really is protected, and you don't have to worry about triggering VA to, if you think VA might reduce the rating, there are protections. As we've said in many episodes, VA doesn't always apply the law 100% correctly across the board, but that protection is a pretty strong protection. The 20-year protection is a very strong protection. So what happens if VA wants to reduce your rating? If somehow VA, for whatever reason, and we'll get into some of those reasons that might trigger VA to want to reduce a rating, they need to give you notice of a proposed reduction. So they don't always need to give you notice of a proposed reduction if the reduction is not going to impact your combined rating. And we see this sometimes, if somebody is 94% and severing tinnitus or reducing one of the conditions is going to reduce you from 94%, which is already rounded down to 90%, to 87%, which is rounded up to 90%. You're remaining at 90%, so it's not impacting your compensation. Then VA is not required to give you notice of a proposed reduction. But if that reduction is going to materially impact the amount of money that you get to take home each month, VA has to propose a reduction. And so what that looks like is you get a letter in the mail that says, we believe that such and such condition has improved, and we are proposing to reduce it. The reduction doesn't go into effect right away. You then have 30 days from the date of that letter, not the date you receive it, but the date on the letter, to request a hearing. A predetermination hearing is what they call it, a predetermination hearing to dispute the proposed reduction. It's often a good idea to request that hearing, because VA, if you request a hearing within that 30 days, VA cannot reduce the rating. They can't implement the reduction until after the hearing, and they get scheduled out pretty far. It takes them a while to staff those hearings. And so your rating is protected. You've got some time to gather the evidence you need. to develop lay statements, to make, if you really are worried that they might reduce it, make other financial plans so that, your mortgage and your rent is covered. So you have some time before that reduction could potentially go into effect, and some time to gather the evidence to fight the reduction. So within 30 days of the proposed reduction or proposed severance, you can request a hearing. You have 60 days from that letter to send in written dispute of the letter. So if you don't want a hearing, but you just want to say, hey, VA, I disagree, and here's why. I think you got these facts wrong. Here's additional evidence from my migraine log, additional buddy letters, additional medical evidence that I think the reduction is an error. You have 60 days from the date of the proposed reduction to send that in. You may have longer if, VA might consider evidence if they haven't made a decision after those 60 days. If you missed that 60 days, I would still send in the letter. If you miss the 30 days to request a hearing, I would still request one. VA doesn't have to honor your request for a hearing if you send it in after 30 days, but they might. They do want to hear the evidence and avoid having to have appeals. Believe it or not, if they can get stuff right, they want to get it right. The system just isn't always set up for them to address the evidence correctly. But again, they can't implement the reduction until after that hearing or after the notice of the proposed reduction, and then the final decision that implements the reduction in rating. So you have some time if they propose. I don't want people, it's scary, especially if you're relying on that money and you're used to having that money come in for your budgeting, that VA's proposing to sever, proposing to reduce something. But you do have some time, and it's a good time to reach out to legal professionals or accredited claims agents to assist you and get some guidance on what to do when there's a proposal to reduce. So individual ratings can be proposed to be reduced and can be reduced or severed, but there are these protections around them. That is separate. A static disability or a protected disability rating is related but separate from total and permanent. So you can have an individual rating that is permanent or static and not be totally disabled. Total and permanent is that you have a 100% rating disability and VA has determined that it is permanent in nature. It could have multiple ones that add up with VA's math to 100%, and VA has determined that it's total in nature. There's other benefits that go along with having 100% total and permanent rating. There's state-dependent tax benefits, education benefits. Dependence education assistance is a huge one. So there's a lot of reasons why people are shooting for that 100% total and permanent, other than the increased monthly amount that they get at 100% total and permanent. But you could also have individual ratings that are considered static, which is essentially permanent in nature, unless you do something to trigger VA to reevaluate those. And so some of the biggest errors or missteps that we see veterans make are filing new claims and not understanding how those new claims can impact their existing ratings. So if VA gave you a 20% for your back, and you file a claim thinking your back has gotten a lot worse, you want to file a claim for increased rating for your back, VA is going to send you off for new C&P exams, new compensation and pension exams. And that new examiner is going to look at your back and look at your medical records and your history and all of that. If they measure that your back has gotten better, even if it was a static rating, you had a static rating for your back at 20%. Now you've asked VA to look at it again. So if they look at it again and they see it's gotten better, that might trigger them to look into reducing the rating. If you've had that rating for 5 years, remember they're going to have to show sustained improvement. So a single C&P exam is not enough for them to reduce it if they don't have other evidence that the improvement is sustained. But now you've opened that door to a different C&P examiner who might say, oh yeah, they've got decent range of motion. They can bend down and touch their toes, when the prior examiner didn't think you had that range of motion. So if you open something up that already has a rating, it's important to kind of understand how VA rates stuff and understand your symptoms and what the risk is. Even if your symptoms are worse, are you going to be able to describe them to VA in a way that's going to actually increase your rating? And if VA proposes a reduction, are you prepared to fight that reduction? So there's kind of a risk reward evaluation that people need to do when they're asking VA for increased ratings on things. Again, if you have the minimum compensable rating, so if you got 10% for something, there's very little risk that VA would go in and reduce it below 10% because you're at that minimum. It's kind of a protected rating, so it can only go up from there. There's not much risk. The other thing that we see a lot is people not understanding pyramiding, which is VA can't give you separate ratings for different disabilities that are for basically the same symptoms. So, for example, if you have a TBI, traumatic brain injury, and you have PTSD or depression, they're separate injuries. One is literally an injury to the head, and the other is a mental health disability. But they both could impact cognitive impairment, emotional regulation, mood, speech patterns. The way that VA rates them has some overlap. You could also have a TBI that causes vertigo, migraines, stomach disorders. Depending on what part of the brain is impacted, there can be separate symptoms that can be separately rated, but there is a lot of overlap. And so if you have a TBI and a mental health disability, VA might look into both of those, and now that door is open again, and you've kind of, even though one of them was static, now you've opened the door and asked VA to look at it again. And so if they look at it again, they could propose a reduction if they think that symptoms have improved or if symptoms aren't as bad as were recorded in your first CMP exam. Even more overlap or more caution is that for mental health conditions, you can only get one rating. So if you have PTSD and depression and anxiety, you can get one rating for those. So I've had people ask, well, I have PTSD and my therapist says I also have depression, so I'm going to put in a new claim for depression. You can put in a new claim for an increased rating on mental health, again, understanding that balance. Do your symptoms meet the higher criteria, and is it worth the risk of having someone look at it for the reward of potentially getting a higher rating? But you're not going to get a separate rating for depression and PTSD. So you're just asking VA to open something that was already static. And if you're happy with the static rating, you're kind of setting yourself up for a reexamination and potentially, not a guarantee, of course, but potentially a reduction. The other way that people sometimes, we call it poking the bear. The other way that people will poke the bear is by filing a claim for total disability based on individual unemployability, so TDIU. And with TDIU claims, you're essentially asking VA for a higher rating of your underlying conditions because they prevent you from securing or maintaining substantially gainful employment. So they're interfering with your ability to work. You're asking VA for a higher rating to give you that 100% rating based on your underlying conditions. So VA is going to open that up and say, okay, you said that your back and your PTSD and your migraines are all impacting your ability to work. So let's take another look at your back and your PTSD and your migraines. And supposedly they're looking at how those impact your ability to work. But in doing so, they're going to send you to new CMP exams or try to develop evidence to evaluate those conditions. And in doing so, sometimes we'll see people trying to get the higher rating. They're trying to go from their 70%, 80%. They're trying to reach the 100% based on unemployability. And as VA is evaluating the pieces or the disabilities that are contributing to unemployability, you get some CMP examiner who says, you know what, your PTSD doesn't meet the 70% criteria. I think I'm checking the box that says it's closer to a 50% criteria. And all of a sudden, even though it was a static disability, VA is proposing a reduction. And I don't mean this conversation to be to prevent people or strike fear in people that you never want to poke the bear. You never want to file new claims for increased ratings. It's just kind of a buyer beware, a caution that you want to be working with somebody who knows what they're doing, who is prepared to defend in case VA proposes to reduce something, who can give you guidance that, yes, if you file for this increased rating, based on discussing the symptoms with you and going over the way that VA rates stuff, you actually do qualify for an increased rating, and helping you develop the evidence. You can do it on your own, but these are the times we have people come to us after they've tried it on their own and VA is proposing reductions, and that can be a scarier time, and there's more work to kind of clean up the mess after you've triggered VA to re-examine something that was otherwise static. So this is a really good time to get an accredited claims rep or an accredited attorney on your file if you want to file for things that are related to conditions that you already have connected, or going for total disability based on individual unemployability, TDIU. It can be really helpful to have somebody help you navigate that and make sure that you're filing stuff in a smart way and taking advantage of the protections for your ratings that you have. So just because it's static doesn't mean it's protected. Just because you've had it for 5 years doesn't mean that VA can't reduce the rating. Even if you've had it for 10 years, doesn't mean that VA can't reduce the rating. They just can't sever it after 10 years. After 20 years, VA can't sever or reduce it. You do have that larger protection, even if you file for increased ratings and you're triggering VA to look at stuff. The only way that they can sever something at that point is by showing that there was fraud in your original application. So that's pretty rare. I know most of the people, pretty much all of the people we work with, all of the people we've talked to are just trying to get the benefits that they deserve, trying to maximize the benefits that they're entitled to. One other area that might trigger VA to look at an already rated condition is filing for secondary service-connected conditions. So if you have a back condition and your back condition causes you to walk with a guarded gait, and now you've got knee conditions because of your back condition, if you file that claim for your knees, VA probably will not reevaluate the back condition because they're separate body parts, but it might trigger VA to look at the underlying condition. It sort of depends on how closely related the conditions are. If you have diabetes and you also have neurogenic bowel, so with diabetes, it can impact the nerves that innervate your bowels or your bladder, and you file for that as it's essentially an increased rating for diabetes, but if you file it as a secondary condition, VA is going to look at the underlying condition and reevaluate the whole thing. And in those situations, most likely you would get the increased rating. But again, you're opening that up for VA's reevaluation. So I don't want you guys to come away from this being afraid to go after all of the benefits that you're entitled to. I just want you guys to understand that there's strategy and nuance into what's protected, what's not protected. And when you file new claims or secondary claims or claims for increased ratings, it's important to understand what's protected and what's not protected, and understanding where VA can take another look at your ratings and if something is likely to be proposed for a reduction or not proposed for a reduction. So keep in mind that a proposed reduction is not a final reduction. You still have the right to a hearing. You have some time to gather evidence to dispute the proposed reduction with VA. Deadlines matter. You want to get your request for a hearing in within that 30 days to really lock in your right to having that hearing. If you miss that, you want to at least get your request or your dispute of the proposed reduction in within 60 days. And if you're thinking about what next claims to file or what your strategy is for going for a higher rating, you want to ask yourself, are any of my ratings protected? What protections are they entitled to? Has my condition actually worsened? Has my condition gotten better? Did VA get it wrong the first time that they rated my condition? Has it been worse all along? What evidence do I have of the worsening condition or of the secondary service-connected condition? And is the possible increase in my ratings worth the possible risk of a proposed reduction? So understanding that, I think, can help veterans make smarter decisions about how to pursue their claims, which claims to pursue. And I'm sure I probably triggered a lot more questions than I was able to answer in this short episode. So please put your questions in the comments section, and we look forward to hearing from you. And if you have other topics that you'd like us to talk about, please put that in the comment section as well. And we will see you next time. Thanks for tuning in.